Hi and welcome back to Clarion Solicitors series on Inheritance Act claims. I'm Lynsey Harrison and I'm head of the Contentious Private Client team here at Clarion, and I'm joined again today by Sam Richardson, who's one of our fantastic solicitors specialising in estate disputes.
Hi Lynsey, thanks for having me. It's great to be back.
So last time, Sam, we talked about spouse claims. Today we're going to widen that lens a little bit and look at other people who can actually bring that type of a claim. And of course what we're talking about is, the full name is the Inheritance Provision for Family and Dependants Act 1975, but we call it the Inheritance Act. But it's not open to everybody, is it?
No, it's not. It's quite specific. So there's 6 main categories of people who can claim, and each one is treated slightly differently in terms of the test that's applied.
So to begin with, can you just give us a really quick overview of all of those different categories?
Yeah, sure. So the first category is spouse or civil partner of the deceased, and we talked about that in our last video in some detail. But you've also got former spouses or civil partners. The key there is that they haven't remarried.
Yeah.
You have cohabitees of the deceased, but to qualify for that category, you have to have been living together with the deceased for at least 2 years before they die. Then you've got children, so that includes minor children under the age of 18, and also adult children can bring a claim.
Yeah.
The 5th category is anyone that was treated like a child by the deceased, and then the last category would be anyone financially maintained by the deceased.
Yeah. So that's a fairly broad range of different people, and as you say, the law treats each one of those differently.
Yeah, so it depends which category they fall into. The level of provision that can be provided from the deceased estate depends on what type of claimant they are.
Okay, so let's talk about first spouses. We touched on that last time, but they're the most generously treated, aren't they?
Yeah, that's right. So if it's a spouse that's bringing a claim, what the court will do is they'll look at their claim and assess it as if the marriage had ended on divorce, not death. So in those cases, it's often not just needs-based, but it will reflect sharing and fairness.
Yeah. But what about former spouses?
So former spouses are different. They can only claim if they haven't remarried, so that's the first thing. The second thing that we would need to look at is how their divorce ended, and make sure that there isn't a clean break order that prohibits them from bringing a claim under the Act. So their claims are generally a lot more limited. The court won't treat them like they were a current partner.
But that's one of those really subtle but crucial distinctions, isn't it? That that's why you need to have someone that's a specialist in this type of litigation, just because they will know those distinctions.
Yeah, absolutely. And I think clients are often very surprised about how such a small difference in the paperwork can make such a big difference to their claim.
Yeah. Okay, so cohabitees are a big one, aren't they? Lots of people assume that living together is exactly the same as being a spouse, and that's recognised exactly the same in the law, which it isn't, is it?
No, that's right, absolutely not. So, to qualify for this type of claimant, the other key thing is that you have to have lived with the deceased for at least 2 years before they pass away. So that's one point. The second point is that to qualify, the court will look at the relationship, and they must have been living together as if they were husband and wife or in a civil partnership. So it's not just about sharing the same address.
Yeah, and I think that's something that clients don't always know when they come to us, that the court will be looking at that actual relationship rather than, it's not just about the fact that they shared an address, is it?
Yeah, exactly that. So the court would look into things like finances, were they shared, daily life, family involvement. So you need to show it's a genuine partnership here, and it's not just that house share.
Yeah. And is their entitlement more limited?
It is, yes. So for a cohabitee, it's different to a spouse in that the court will consider what is reasonable for their financial maintenance. So the focus here is on need, not equality in sharing of assets.
And then next up we've got children, and that can include obviously both minor under 18 children, but also adult children as well.
Yeah, that's right. So for minor children under 18, they're probably more straightforward claims, because what the court will look at is what's the financial need of that child, and we can quantify that quite easily with things like provision for their upbringing, education, general welfare. For adult children, it's harder. So the court would expect some level of dependence or a particular need that we can hook the claim on there.
Yeah. So I think the really important point is that just because you've been left out of a will doesn't automatically mean that you won't have a claim.
No, exactly that. So, you know, these types of claims are about needs, financial needs, and not disappointment. And I think sometimes clients come to us, don't realise that until they've taken the advice and we've had that conversation. So there is a case called Eilert and Mitson. It's you know, a few years ago now, but it's still really good law. And in that case, what the court did is recognise that the adult child had a financial need, but they had to very carefully balance that against the deceased wishes.
Yeah. And then we've also got the child of the family and dependent categories as well, and they're a bit less common, aren't they, but still very important.
Yeah, I think they are important, especially in today's world where we have more and more families that are not traditional families.
Yeah.
So this type of claimant would cover individuals that a deceased person treated as their own. So, for example, stepchildren, foster children, maybe you know, a grandchild that they raised as their own child. Yeah. The key here is whether or not the deceased assumed a parental role for that child.
And what about dependents?
So that's anyone really that was financially maintained by the deceased. Thinking of examples of cases that I've worked on, that could be a partner, a relative. I've even had a case where it was a friend that was financially maintained by the deceased. In those cases, it's really important to show actual financial support. So it's not just the odd gift or the meal out or a favour here or there. It's continuous actual financial support.
So our job really is to get together the best possible evidence we possibly can. So we're always looking for things to evidence what's happened. So, you know, bank statements and bills and things like that, they become really crucial, don't they?
Yeah, absolutely. So as with all of these cases, the more evidence, the stronger the claim.
Yeah. So when someone first comes to us as a client, what's the first step that we would take for them?
So first things first, we would identify which category of claimant they fit into, and that then kind of sets the framework for the rest of the claim. So we talked about the different types of tests for spouses versus the other categories. We'd need to look at that first, and then what we do is we assess the financial position of the claimant. We would then also look at the estate, so the size of the estate, what is the estate made up of, and then going back to the evidence point, we do a detailed analysis of what evidence the individual's got.
And always with one eye on the time limits, which are very, very different to other types of claims, aren't they?
Yeah, and quite short actually. So we need to be really careful with this. So claims of this nature need to be issued or settled within 6 months of the grant of probate or grant of representation. So it's quite a strict deadline. So I would say that early advice is key in these types of claims.
And a lot of our claims, you just mentioned there about claims settling, a lot of our claims, especially these types, are settled without having to go all the way to court, aren't they?
Yeah, definitely. I would say the majority of our cases are settled at mediation or alternative means of dispute resolution. We try our best not to go to court if we can, because it's just less stressful, less costly, and it can be done in a much quicker timescale than going through the court process. Yeah,
and the thing I really like about mediation is it can be really flexible, and you can add bits and pieces in there that the parties actually need in a way that you can't do that in the court, can you?
No, and it keeps the control with the parties, doesn't it? If you go to court, you're handing it over to one person to decide the outcome of the case. And what I would say about these types of cases is the court has such a wide jurisdiction.
Yeah.
It is a risk to know what you're going to get, whereas at mediation, it's the parties that decide between them what the outcome's going to be.
Absolutely. That's a really great summary. Thank you, Sam. It really highlights how the Inheritance Act can help, but it is only for certain people in certain circumstances.
Yeah, no, that's right. And what I would say about these types of claims is it's not about rewriting wills. The court's very clear about that. It's about satisfying claims that people have that are genuine dependents of the deceased, but there's a very careful balance as well of balancing the deceased wishes and not straying too far from that.
Yeah. Well, thanks again for joining me.
No worries.
And if you'd like to know more about Inheritance Act claims generally or speak to any of the team, you can find all of our details on Clarion Solicitors' website. Thank you.
Thanks.